The long-awaited public release of the National Register for Sex Offenders, NRSO, has been delayed, sparking both hope and concern. Joining us is Sibongile Ndashe, Executive Director of the Initiative for Strategic Litigation in Africa, to discuss the implications of this day. Sibongile, thanks so much for joining us. Now, can you explain the purpose of the NRSO and why its public release is so significant?
The National Register of Sexual Offenders, basically, it's something that we had in the legislation from as way back as 2007. So I think it's important for people to just understand the context of where it's coming from. And this came in when we were passing the law to deal with sexual offenses. And the idea behind this register is to prevent people who have been convicted of sexual offenses from being employed in certain sectors, like working with children or working with people with disabilities. So groups that are considered to be vulnerable groups. So the idea is that when people are arrested or convicted of sexual offenses, then they will go into this register. But the law actually sets out who has a right to access this register and also for what purposes. And that is why for many people who are working on gender-based violence, I mean, there are people who obviously believe that having a list of perpetrators kind of published will be helpful. But when one sits down and thinks about it, in a context where only about 10% of offenders are arrested and convicted, and how reactive, it is, and looking comparatively at other countries that have had these laws, when the questions are these laws, the national register really an effective way of combating gender-based violence? And so sometimes I think people do feel that it's a little bit gimmicky, something that's a feel-good factor, that makes people feel like something is being done to combat gender-based violence. Because on its own, just publishing the register will need an institutional framework. You would need to amend the existing legislation. But more than that, you would have to couple this with other things like effective policing, effective referral mechanisms, better way to protect our children and people with disabilities. And this really takes us back to the question of how resourced all of these things are.
So can you provide more detail on the types of crimes that have led to individuals being listed on the National Register for Sexual Offenders? Are these primarily recent offences, or do they also include historical cases where perpetrators have already served their sentences?
So, like I said, the beginning is we've had this register for 18 years. This register was established, in 2007. So if it is managed effectively, you would have people who, at the time, when the register was created, then they would go, into the register. So we are talking about that kind of time frame. So then one of the things, because this was initially not designed to be a public register, so the registrar and the people who are working there, in fact, it's a criminal offense to divulge information that is there, could not share this information, but there were very, very, very specific offenses, instances where the register, could be shared. So if someone was looking to adopt a child, for example, then a person would have to go and get confirmation from the registrar to say that I haven't been convicted of a sexual offense. If someone, whether in the public or private healthcare, was looking to employ someone, to look after children or people with disabilities, they would be able to go there and access that register. But the types of offenses that are there are specifically those of sexual offenses that are listed in that register. But of course, there is a conversation about expanding the scope, of there, and then publishing lists of people who have committed gender-based violence and femicides, but that's not what's in the sexual offences legislation.
So for those who've served their sentences, right, what mechanisms are in place to ensure their rehabilitation and reintegration into society? And how does the register balance public safety with the rights of the rehabilitated offenders? And I suppose it also raises the questions of outside of them seeking employ in particular instances, how then do we protect our children or those relatives of ours that are disabled, who've been offended by these individuals?
So I think that's part of the ongoing conversation around the use of the criminal justice system and the purpose of correctional services. So there is a tension. So people who are working on rehabilitating people who have committed crimes, they do say that we do not have a lot of that happening, in our prisons. So there hasn't been an investment that ensures that people who come out of prisons are better able, to integrate in society. In fact, in some instances, people say people go to prison to actually graduate and become better criminals. Now, but there are people who are doing this work and saying that if we are going to leave, we cannot just approach everyone who's coming back from prison with this idea that once you are a criminal, you are a criminal for life, because they have paid their debt to society and deserve a fair chance, to be reintegrated. So that's one argument. Then there is the other argument, which is about saying, yes, but we are still scared of people. In fact, if people are saying that people are not rehabilitated in prisons, then how can we trust people who have come, from prison? And so when we are talking about this work on preventing violence and what's the duty of correctional supervision, because if society feels that people need to be known because we need to fear or be scared of the people who have been convicted, then even those who have been rehabilitated, they run the risk of what's happened. Some of the things that happens, it's really what happens to their families, their children, that they get stigmatized, right? They struggle to get information, and these are some access to employment. And these are some of the concerns about a publicly accessible register that's not trying to protect specific groups, but basically it's a name and shame, and all of that. And these are very difficult things, to balance, because here there is a fear factor that really comes from an ineffective correctional services process where people are not rehabilitated. And on the other side, this has to be balanced with people, especially those who have really done work on themselves, to be able to integrate in society and be given a second chance.
Sibongile, you speak of second chances, but let's talk about repeat offenders. What is the incidence of repeat offenders of these individuals who are currently on the National Register of Sexual Offenders?
So right now, because these are kind of private, it's they're not kind of publicly accessible. It's very hard to say. But some of the statistics that we have just about generally how people kind of reoffend in terms of sexual violence, it's about the people who have been sentenced or convicted for sexual violence make less than about 5% of the population, right? And this is not because people do not reoffend. This tells us a story about the ineffectiveness of the criminal justice system, So sometimes when people have been arrested, they know how to beat or kind of work, with the system. So we don't have a story that tells us that, yes, when you have got this register, you are going to be able to catch repeat offenders, because this should be available to law enforcement, officers. It's not us that are going to catch or investigate, what has happened and all of that. So what is really interesting is to understand or see how, if this register becomes public, because there's going to be a framework for doing this, how all of these concerns are going to be balanced. And that's why when the minister made this public announcement that it is going to be done so by the 28th, first of all, the concern was there is no legislative or institutional framework for publishing, this register, even though some activists have been calling for it to be made public. But more importantly, this is something that could open up the state, to criminal, to constitutional challenges for the right of people who have served, to think about what is it basically that you are trying to do and what is the cost benefit analysis, because we don't have a lot of evidence that says making the register public actually helps to deter crime.
Now, final thoughts. You've kind of given us the opinions of two schools of thought, right? From your professional perspective, what would your recommendation be?
I haven't heard kind of evidence right now, and just looking at it globally or kind of in terms of comparative law, the evidence as well. So I align myself with a school of thought that says, where's the evidence that publicizing, like publishing and making it accessible to everyone is something that's going to help us. So I keep on going back to saying these kind of gimmicks, because I think it is a gimmick at this point, without really reinforcing the things that are going to keep us safe. It's populism, at its best, because it gives people a false sense of security that something is being done, in order to protect us from all of these violent criminals. So what we really do need to see is the improvement in funding the response, is the improvement or improved kind of policing, investigation, the quality of the prosecution, and obviously the investment in better rehabilitation programs.
Sibongile Ndashe, always good to speak to you, Executive Director of the Initiative for Strategic Litigation in Africa, speaking to us around the long-awaited release of the National Register for Sex Offenders.